I guess we can get started. We have two guest panelists today, as many of you already know. We have John Dehn, who's the non-resident senior fellow in West Point Center for the Rule of Law, and a former professor at West Point. And we have Philip Alston, who's a current professor at NYU, and has written reports for the UN. All right, we're going to do a debate format. First will be John Dehn, 10 minutes. Then will be Philip Alston answering for 10 minutes, followed by John Dehn's rebuttal for 5 minutes, and Philip Alston's rebuttal for 5 minutes. And then we'll have some time for questions and answers. Okay, that's all you have.
Well, thank you, Alex, and thanks to Fordham and the various groups that have sponsored the event for inviting me here to speak. It's a pleasure to be here. I've been to Fordham a few times and always enjoy coming to Midtown. As is typical, I have to, of somebody who's associated with the military, I have to give several disclaimers. And the complexity of the disclaimers that I'm giving are on par with the complexity of the topic that we're going to be speaking about today. First of all, I am still on active duty in the U.S. Army, but I'm not speaking at all in my official capacity. My relationship with West Point as a non-resident senior fellow is in my private capacity, but it's still an official a relationship with the federal government. So I still have to provide the standard federal government disclaimer that my remarks today do not necessarily reflect those of the U.S. government, the Department of Defense, the Department of the Army, or of West Point. I also want to make clear that I am not at all going to discuss policy regarding targeted killing in terms of, I don't have a say or an opinion on whether it's good or bad policy. It's really dependent on the context. My focus will be, in my remarks will be on the law, and I'm going to do that by reference to Professor Alston's report when he was a UN Special Reporter, and talk about areas where we agree, which are a great many, actually, and areas where we might disagree. And I think as well, some of the differences that we have may be a little bit less in the current under the current administration, perhaps, than under the former administration. But nevertheless, we'll get into that. It's definitely busy times for targeted killing. We've had revelation that the Attorney General is going to come out and speak about al-Awlakhi's targeted killing. We've had a recent event in Yemen against a suspect in the coal bombing. We've had, thanks to Fordham's morning brief from the National Security Center, I know that we've had another strike in the Philippines against suspected militants and terrorist leaders. We have the President's remarks on YouTube about certain programs that may or may not exist, and now an ACLU lawsuit on the basis of those remarks. So we may finally get to some more information about what the government thinks in terms of the law governing targeted killing. But all I can do is speak based on publicly available information, because that's all I have access to. And in publicly available information, the United States has asserted alternate, I think Phil's report called it an additional basis, but in my view, they're alternate bases for targeted killing. One is that these targeted killings occur in the context of an armed conflict against al-Qaeda and associated forces, a term that Phil doesn't like so much, but we'll talk about our differences there. And the other, that they are also supported by independent acts of self-defense, what my good friend and colleague Ken Anderson has called naked self-defense, or self-defense outside the context of armed conflict. So each obviously has an international and a domestic law component, and I'll get into as much of that as time will allow. Probably more international law than domestic in terms of remarks and rebuttal, because that's Professor Alston's area of expertise, but certainly willing to talk more about the domestic law aspects in question and answer. First of all, let's understand that in both international and domestic law, targeted killing has two components. What we in the use of force arena call the use ad bellum and the use in bello. or the resort to armed force, and the law governing the actual use of that force. Now, use in bello is a problematic term here because when we're talking about situations outside of armed conflict, it's not really an appropriate term. We're more looking with reference to human rights law. But the dichotomy still exists. You have law governing the actual resort to force in the territory of another state, and we're going to talk about extraterritorial target killings primarily today, and then the law governing the use of that force. With regard to the resort to force, I am in complete agreement with Professor Alston. The United States can and does resort to force in the territory of other states, either with the consent of that state, or when that state is unwilling or unable to suppress a threat to the United States. I believe that, some have said that this is an analogy to the law of neutrality. Some have said that neutrality law only applies to international armed conflict and is inappropriate in this context. Professor Alston's position on that is not at all free from controversy. But I do agree that the resort to force in the territory of another state can occur when that state is unable or unwilling to suppress a threat to the United States. And I believe that position is strongly supported back in the very origins of international law. The origins of international law are heavily natural law based. And it was a fundamental principle of natural law that states were perfectly sovereign and perfectly independent and free to do what they will, but so long as they did not infringe upon the rights of other nations. And part of not infringing on the rights of other nations was preventing your territory or your nationals from injuring other nations or their nationals. We see this reflected in the U.S.'s Alien Tort Statute. We see it reflected in the Neutrality Acts of the United States. And so I believe that the unable and unwilling test has a strong legal basis and historical basis as well. So that's not really where there's a lot of interest or a lot of interesting conversation to be had. The real interesting section is with regard to whether the applicable paradigm for the actual use of force or the armed attack that occurs is the law of war, or also known as international humanitarian law, or international human rights law. Now, Professor Alston's report and a great bit of the commentary kind of presents these bodies of law as a fully complementary and an almost dichotomous regime. It's either one or the other, and there's no room for some kind of hybrid between the two. Although they will say, and I agree, that international human rights law to some extent does apply even in the context of armed conflict. The question is not whether it applies, it's to what extent all of the rights preserved in documents such as the International Covenant on Civil and Political Rights actually apply in that context, and when are they displaced by the rules of international humanitarian law. But with that point aside, we agree that in armed conflict, there are two categories of individuals who can be targeted with lethal force. Those are combatants, or who are members of armed forces of a state party to the conflict, or other volunteers, corps, militias, who, whether or not they're incorporated into the armed forces, who carry arms openly, who fall under responsible command, who conduct operations in accordance with the law of war, and who wear a fixed insignia recognizable at a distance. Those folks can be targeted at any time, anywhere, subject to the caveat that targeting must always be necessary. Now, we can argue about whether that necessary is McCulloch v. Maryland helpful necessity or some sort of stricter form of necessity, but it has to be necessary to achieving some military objective. There's another category of individuals who can be lethally targeted in armed conflict, and those are civilians who take a direct part in hostilities. And again, Professor Alston's report is very good on this point, and I'm in full agreement with him that we cannot take an expansive view of direct participation in hostilities. Direct participation in hostilities truly does include direct participation, perhaps one causal step removed from the actual infliction of harm on the enemy. And I also agree that the U.S. has taken, at least under the former administration, a bit too broad of a view of who might be a civilian taking a direct part in hostilities. There was a period of time, not very long I don't think, which the U.S. targeted poppy farmers in Afghanistan because they said the poppy farmers sell their opium and fund the insurgency and therefore they're a proper target. That's basically the same justification Osama bin Laden used for attacking the World Trade Center. I didn't accept it then and I don't accept it in that context either. But those civilians who do take a direct part in hostilities, who act in support of hostilities and in connection to ongoing hostilities or armed attacks are certainly targeted. In non-international armed conflict, there are fighters and civilians who take a direct part in hostilities. Now, this is a point in Professor Alston's report where he seems to take issue with the International Committee of the Red Cross's recent guidance in this area, talking about the fact that there are those who engage in a continuous combat function and therefore can be targeted basically on the same basis as combatants, and those who are only supporting hostilities and therefore can only be targeted when taking direct part in hostilities. The difference in targeting, the very important difference, is a temporal one. Combatants can be targeted at any time, anywhere, provided that their targeting contributes to the achieving of a military objective. Civilians taking a direct part in hostilities can only be targeted for such time as they're taking a direct part in hostilities. Now, obviously, in international armed conflict, where it's difficult enough to distinguish between who's a civilian and who's a combatant, distinguishing between who's a civilian with a continuing combat function and therefore the functional equivalent of a combatant, who is a civilian taking a direct part in hostilities and therefore can only be targeted when they're doing so, and who's just a plain old civilian, that can get a little hard. And Professor Alston's report mentions that as a reason for concern about targeted killing, and I agree. But the important aspect of all of this is it requires the context of an armed conflict. And it requires targeting of someone who's a party to that conflict or civilians who are directly supporting the hostilities of a party to that conflict. And this is where Professor Alston and I probably disagree the most. It's not that I disagree with him that associated forces of al-Qaeda have to be looked at very carefully. But his report seems to indicate that associated forces almost necessarily, and I'll be happy for him to correct me, almost necessarily cannot be party to an armed conflict of another non-state actor. And I don't think that that's necessarily true. I do agree that targeted killing requires the existence of an armed conflict and requires somebody who's subject to lethal targeting in that armed conflict, subject to the principles of distinction, proportionality, and necessity that always apply to such targeting. But I do believe that those entities who not only have, they can't just have an ideological alignment against the United States. There has to be coordinated activity. If there's coordinated activity between an al-Qaeda cell or some other terrorist group and al-Qaeda, with which we're engaged in an armed conflict, then I believe that members of that group with a continuous combat function are targeted. And likewise, civilians who who are directly participating in hostilities, although there can't be few, especially the farther you get away from an active battlefield, are also targetable on the same basis as they would be in any armed conflict. Then the next question becomes, well, what about the battlefield? Do they have to be on a battlefield? Can they be off of a battlefield? This goes back to the very origins of the law of war. The law of war, as a body, developed with regard to the belligerent intercourse of parties, meaning all matters of the conduct of hostilities were subject to the law of war, wherever they occurred. There was no territorial nexus requirement. Wherever those parties engaged one another, the laws of war or international humanitarian law applied to that. I think the concern here is that we're worried that in a situation where a state is otherwise able to govern its own territory to arrest and prosecute terrorists, that it would be inappropriate to apply international humanitarian law to permit the targeting of someone. But that gets us back to the first question, the use of bellum question. Where the state is willing and able to suppress a terrorist threat, there would be no targeting. There would be no use ad bellum, right, to use force. And if we were to allow consent to fulfill that requirement, under those circumstances, I believe that state itself would be in violation of its human rights obligations. But when that state itself is unable to suppress that threat, I'm not necessarily certain I agree that we automatically have to resort to an international human rights law paradigm. And for the sake of time, I'm going to compress my thoughts on these into this. There's a lot of commentary discussing terrorism and the new threat that it presents, and there's also related ideas of the responsibility to protect and intervention in the domestic affairs of the state when it's not protecting its citizens from widespread and systemic harm. And we also have this unwilling and unable standard that allows for a use ad bellum right to use force in the territory of another state. What we might be seeing, and this is just an academic thought, is the development of an international law of ungoverned spaces, or ungovernable spaces, or perhaps you could call it international martial law. Okay? Now, martial law is a problematic concept under any human rights law treaty, certainly. And martial law is even a problematic body of law even within our constitutional system. But it has existed within our constitutional system in the past. It's been recognized in Supreme Court precedent. And it seems to be perhaps descriptive of what we see states doing with regard to extraterritorial threats by terrorists. And so with that, I'm going to stop my remarks and let Professor Alston respond and look forward to your questions.
Thanks, John. I'm going to disappoint you all by not really debating so much with John Dehn. It's, first of all, a great pleasure to be here at Fordham, my second favorite New York law school. My wife was actually on the faculty here for a number of years, and so I've spent quite a lot of time here in different capacities. Very nice to be back. John has mentioned that in my UN capacity, which I occupied for 6 years on a part-time basis as UN Special Rapporteur on extrajudicial executions, I did a report on the United States, and I also did a separate report on the practice of targeted killings, looking at the national law. And I think John's given a very good representation of the issues there, and I'm pleased that he is in agreement with so much of it. I really want to talk much more about the policy dimensions of targeted killings, which he is less free to do given the disclaimers and so on, but which I believe to be even more important than the fascinating legal issues, which I will come back to at a certain point that John has raised. Two forms of targeted killings are of concern to me. The first, drone-based killings, are the best known. The figures vary, around 300 strikes since 2008. Between 2,000 and 3,000 people have been killed. We don't know how many of those are civilians. Estimates vary between a mere 138 civilians and 780 killed. And one of the problems that I have, of course, is that we don't know any of this, and we were given yet another serving of that, unfortunately, by President Obama a few days ago, saying, "Don't worry, guys, we're really careful, and we killed very few civilians." Well, thanks, Mr. President, but I'd like a bit of data rather than your assurances on something like this. We don't have any data. Second are the so-called kill capture raids. Now this, basically when bin Laden was killed, it was a kill capture raid. On the day after Leon Panetta, then at the CIA, said, "Hey, what's the big deal? We do loads of these every night in Afghanistan." And he's right. They do. Loads of them. It's terrific. So for both of these activities, the way in which we go about them is to establish a a so-called kill capture list. Officially, however, we don't actually know what lists there are, what criteria are used, let alone who's on them. The research that I've done would seem to indicate that there are at least 6 separate lists. If you want to call out your names, I'll tell you if any of you are on them. The 6 separate lists are drawn up at least by the CIA, which certainly has its own, by special forces, so-called JSOC, Joint Special Command Operations, Special Operations Command rather. There may be a separate list that DoD, Department of Defense, maintains separately from JSOC. There is certainly an ISAF/NATO list in relation to Afghanistan and Pakistan, and maybe there are more. We don't know how long these lists are. The CIA acting legal counsel shot his mouth off a little while ago after he left office and said, no problem, only about 30 on the list at any time. Good. But the military testified to Congress about a separate list of 367 in 2009, 50 of whom, as John hinted, were linked to drugs rather than to terrorist activities per se. WikiLeaks seems to indicate that the list in Afghanistan has well over 2,000 names on it. So what are the issues that I'm worried about? Well, first, as I said, you've got complete secrecy as to the process used for these lists. Now, there's lots of claims of double checking, etc., and of approvals and so on. What we do know from Afghanistan and elsewhere is that it's very hard to actually be accurate and to be confident of information you get for targeting. When I was in Afghanistan, there were many stories, one of which I followed through very closely, of people simply wanting to get rid of other people. Maybe troublesome neighbours, maybe business competitors, and so they spread the word. Did you know John Dehn is very sympathetic to the Taliban? Oh, really? Okay, good, thank you. That goes on a list. Now, ideally, someone's going to say, hang on, we've looked at Dehn, no way, this is ridiculous and we've got no evidence. But we don't know that. We don't know exactly what processes are used and how people end up on a list, which leads to their being assassinated through one of these different means. The combatant requirement, that's a point that John mentioned. Again, I hope that he's right in terms of saying that the administration or the Department of Defense now uses a narrow definition and the drug lords, etc., are not on it. But I don't know that. I haven't seen any statement. I haven't seen any list of the criteria. I don't know how it's done. It's all in secret. There's a big problem in the fact, for me at least, that the CIA is the lead agency on a lot of this. The CIA is an intelligence agency, as some of you may know. Intelligence agencies are not generally supposed to be operational agencies in terms of carrying out major military programs, let alone carrying out extensive killings in a place like Pakistan. And yet the CIA is wholly in charge for reasons that are really very problematic. In brief, this leads to a much bigger issue that I'd be happy to talk about, and maybe I will do it in conversation. But you've got basically a militarization of intelligence functions combined with a very determined interchangeability between the military and the intelligence forces. Now, from an operational perspective, it's great. We don't worry about who is from the CIA, who's from DoD, who's from Special Operations. We're all Americans. We've got to kill these bastards. You're best placed, you do it. It's a bit of a problem there. We've set up these different functions very clearly under different titles of the US Civil Code. Titles 10, Title 50, governing the Defense Department, governing the CIA. wholly different range of responsibilities, wholly different rules about when they can engage in activities overseas without notifying, without getting a presidential directive, wholly different in terms of congressional oversight. The respective congressional committees do not cross borders. If this is carried out by CIA, it goes to the intelligence committees. If it's not, it's armed forces committees. So this very deliberate effort, which has been going on now for a long time, we're now reaching the culmination of maybe 15 years of concerted effort by those behind the scenes to really have complete what's called double hatting. So the Bin Laden operation, who carried it out? The SEALs. Hang on, I thought Panetta was in charge. But he's CIA. I don't understand. In other words, what you had was the classic operation that was carried out under CIA auspices because the DOD, the Defense Department, is not authorized to operate in Afghanistan, in Pakistan. But the CIA can for various reasons. And therefore, it's a CIA operation carried out, however, by the SEALs. In other words, you've got this interchangeability. And with it comes major problems in terms of any form of accountability. I think you know the CIA position. It's been in the press a lot, actually, because Obama talked about drone raids. Naughty man. Not allowed to talk about it because this is confidential. No one else has talked about it. In his previous comments, he has talked about certain operations which led to certain deaths about which we're all very happy. These sort of euphemisms. But the CIA official position, restated endlessly, is we cannot confirm or deny that we are engaged in any, what do you call them again? Drone strikes. No? Not sure we know anything about them. And even if we did, we're not going to tell you anything. That then goes all the way through to the courts. And the courts uphold it. The courts say you cannot ask the CIA for any information under freedom of information because you don't have any proof that the CIA is carrying out this operation. The CIA will tell you, we cannot give you any figures for civilian deaths because who says we're doing any of this? While behind the scenes, they are leaking very systematically, listen, first of all, we're incredibly careful with what we do. Secondly, we haven't killed more than 20 people, civilians that is. And so in a recent paper that I just published, a tediously long paper, I've tracked down the various CIA statements which go from, well, we haven't killed more than 20, or we haven't killed more than 30, or we haven't killed more than 40. And then, of course, you get John Brennan, National Security Advisor, saying, fortunately, we haven't killed anyone. It's the first military operation in the history of the world where no civilians have ever been killed. It's great. It's remarkable efficiency. The issue is that you've got a major set of killing programs going on, and it's all completely under the radar. It's all secret. Congress is not involved in overseeing it. We don't know what's being done in our name. Even if we're very much in favour of the fight against terrorism, who wouldn't be? I'm totally for it. We should be very concerned about this particular development. Linked to it, this is more bizarre to me, but as my accent will tell you, I am not American, still not American, I'm Australian, which is almost an irrelevancy in this context because Australia does absolutely everything that the United States does, including in these areas. But in the United States, we have this Special Operations Command, JSOC. How big's JSOC? 25,000 troops, more than 50,000 staff, its own intelligence division, its own drones, its own reconnaissance planes, and its own satellites. Has a presence in at least 120 countries. It is a separate entity within DOD. Separate. It reports direct to the Department, to the Secretary of Defense. It does not go through all of the line management. It has been called consistently by a range of authors across the board as a sort of secret army within US DOD. We know almost nothing, but go to the website, you'll find it all. The JSOC website. You'll find one page which says JSOC, which is already in advance because I'm told that the official position I was told this by the head of counterintelligence, the Counterintelligence Center, just a couple of months ago, that the official position still was that JSOC has no official existence. It is not formally acknowledged in documentation. Go to the website, you'll see a reference to JSOC saying we do great things. If you want more information, provide all your details here. Be warned that we will keep track of your information, etc. I didn't do it. I don't want to be arrested as or hit as an alien terrorist or whatever. But one of my students did, and she told me that as soon as she got in, there was no information. It was, sorry, you'll need to get further authorization or whatever. We don't know what is actually happening. Now, this is big time because the future is largely comprised of drone warfare. There are more drones, more people being trained by the Air Force to fly drones from sitting in a seat like this in Nevada or wherever than there are pilots. The amount of money going into new research for new drone technology is immense. The war in Libya was not a war, as some of you will know. The US flew hundreds of raids, killed many people, but there were no US troops on the ground. It was all done remotely. Therefore, War Powers Act was not triggered, therefore not the usual reports to Congress, no approval for that effort against Gaddafi. That, again, is the future. So drones killing without any real accountability, I think, is a huge problem. And I think we really need to start addressing it in a very systematic way. Finally, there are major problems in terms of setting precedents, and this is one of the big issues. There are now at least 50 countries that have drones. Some of them are arming them. Iran has significant capacity in this regard, but China is also a major producer of drones. The rules that we set today, which say that we can fly drones over any other country and we will not disclose the basis on which we are assassinating people, are the rules that those countries will be able to invoke for themselves in the near future. I think we are shooting ourselves in the foot, and what we need to do is to bring out all of this into the open, acknowledge the rules, provide the information, and permit people like John and I not to engage in what would actually be a shadow boxing exercise, where John would say, well, I don't think we're doing that. You know, I know these guys, they're really decent. I've met a lot of them, and they're really decent too, and they sound very convincing. But I'm sorry, an American military person is not fundamentally different from a Russian or a Chinese military person for me, as someone who wants to know, are you complying with the rules? And the way that you can show me is to provide some information, some evidence. Don't just say, trust me. I don't. I'll leave it at that.
I think I can engage on a few of Professor Alston's points, but they have to be minimal. First of all, I am equally concerned about the evolving relationship between the Central Intelligence Agency and the military. I've written briefly about it, provided an interview for an article that's coming out in the Year in Defense Review or Defense Year in Review or something like that. Others are, Bobby Chesney in Texas, and others are also actively engaged on this point. There is statutory authority for the military, and actually any agency of the federal government, to participate in covert operations. It's not a secret, it's in the U.S. Code. But there are certain alarming implications of that if we make it, as Philip said, a major effort and one that has potentially global reach. There are also implications because the code permits, it doesn't, it says that the participation of other agencies will be subject to their own rules on participation in these exercises, and so there's I have a concern about whether the Uniform Code of Military Justice still applies to folks who participate in Central Intelligence Agency covert operations. And I wrote about this a little bit right after the Bin Laden raid, and it's something that I'm still interested in tackling. I also agree with Professor Alston that we need transparency to an extent. The question is, what's the source of law that requires it? Probably the biggest disagreement I would have with Professor Alston's report was not his general discussion of the law, but on the requirement for transparency, particularly in military operations. And I believe the statement in his report was that international humanitarian law and international human rights law both require transparency. And whatever is true of international human rights law and the requirement for transparency is, to my mind, not sufficiently established in either the treaty or customary law of international humanitarian law. And I say that because if you look carefully at the citations provided in the report, you know, they have the principle underlies some very specific rules, like you have to have medical records accessible for internees, so that you can be, so that an outside observer can look at them and decide whether they're receiving both necessary medical treatment and not receiving any unnecessary medical experimentation. It's not a general requirement for transparency. In fact, there's never been a requirement for transparency in military operations. And additionally, I believe that transparency is not required by international humanitarian law because even in the rules of the International Criminal Court, under Article 72, there is a virtually absolute right to maintain state secrets. Once a state believes that its national secrets are crucial to preserving its security, believes that something might be revealed, it can go to the court and intervene. There are various mechanisms similar to the way the U.S. handles classified information in camera proceedings, what have you, but at the end of the day, and there's also a reference to the duty of cooperation with the tribunal, but at the end of the day, a state can say, there are no circumstances under which we are comfortable sharing this information, even under the Rome Statute. So if we're going to look for transparency, I think we're going to have to look to national law, and unfortunately, we have a lot of national law that allows for a lot of secrecy. Now, you know, I'm not a social scientist, but you know, there seems to be an increasing willingness, predicted by the drafters of the Federalist Papers, actually, for Americans to give up their civil liberties in the interest of safety. And we're willing, we don't know what's in the federal, it's too long, it's too complex, it's too confusing. We don't know what's in there, but a lot of the things that concern Professor Alston are actually established in unclassified U.S. code. And so we can change it, but it's changed through our normal democratic processes. If we don't change it, we have no one to blame but ourselves. I will say, though, that I do believe, and have been clear on this in other places, that the targeting of an American citizen, while Supreme Court precedent clearly implies, it doesn't actually hold, but it clearly implies that U.S. citizens who are targetable under the laws of war in an armed conflict are also targetable by the U.S. government on the same basis as any other enemy combatant. That's implied from the prize cases, a Spanish-American War case, ex parte clearing. There's a list of cases that allow U.S. citizens to be subjected to war measures when identified as an enemy combatant properly. But also there's been review, judicial review of the status of the individual who was targeted. Not before the attack, but after, usually in claims for loss of property or lives. And I think that judicial review, the holding in the Aliki case, that the President's decision to attack an American citizen, even overseas, is a political question, is absolutely incorrect. Particularly with regard to American citizens, there are mechanisms, Bivens actions, and the like, by which federal courts should feel constitutionally compelled to provide review of the government's actions.
Okay, thanks, John. You've been admirably brief. I should be likewise. Where to begin? Well, I'll just tackle the issues you raised now. First of all, the issue of transparency. Transparency is one dimension of a broader concept of accountability. And accountability is for me at least, is the essence, not just of human rights law, but of international humanitarian law. In other words, states bind themselves by signing on to a whole range of treaties to only use force under certain circumstances, to accept certain exemptions, to accept certain constraints, and so on. If there is no accountability, the whole law of IHL is a joke. We're going to have Iran saying, oh, absolutely, there's not a single provision in all of the treaties that we don't respect. Rest assured, we've looked at all these very carefully. Bottom line is, we need accountability. So the question is, how much transparency does there need to be in order to achieve that accountability? Now, I don't disagree with John. We're not talking about comprehensive operational transparency. You know, tomorrow at 9 a.m. we are planning a strike against Philip Alston, etc. But no figures at all, no data as to how lists are compiled, no after the event accountability. The US Department of Defense consistently does mount major review processes when it's alleged that civilians have been killed. And there have been some major reports, and some have admitted major screw-ups. We got it wrong. We really did badly on this. We're going to change our practices. You're aware of all of the CIA follow-up reports, aren't you? If you are, you should go straight to prison because it's all secret. But of course there haven't been any because we haven't killed any civilians. I'll leave it to you. You know, transparency, yes, it's got limits, but there is a certain element if you're going to have accountability. Next, John said we've got to give up a certain degree of civil liberties in the interests of security.
So we have, not that we have, that we need to. We have.
We have, okay. I mean, that's a pretty awful proposition unless one scrutinizes it very, very carefully and puts in all of the necessary safeguards. What's interesting in terms of my focus, particularly on the CIA, is that American law and the political institutions are full of accountability mechanisms. We've shown ourselves in the past to be deeply worried about a CIA running roughshod in Vietnam or wherever, about conducting killings, targeted assassinations around the world. We've passed all sorts of acts. We've set up endless mechanisms. The sad thing is not one of them is functioning today. The President's Oversight Board for Intelligence does not look at these sort of exercises, takes no role. A Civil Liberties Board that was set up after 9/11 has not been activated, including by this administration. The CIA Inspector General, again, huge controversies, etc., led to that position being created with great independence. All of the information that is available, and it's a reasonable amount, shows either that the CIA Inspector General is entirely ineffectual on these issues, or when he has kicked in and caused trouble, there's been total pushback by the CIA, supported by the political authorities. Congress. There are all these congressional oversight arrangements, they simply don't work. The courts now, you've only got to say the word CIA and the courts will say, sorry, this is a political issue or it involves state secrets, we're not going to do it. The CIA has a free pass in United States courts. So, you know, that when we say there's got to be a trade-off between civil liberties and security, we have the principles there, but they're simply being ignored. Finally, the issue of targeting of US citizens. I pretty much agree with what John has said, but you've then got the incoherence of a man who is actually very polished and skilled, Leon Panetta, a few days ago. Without getting into the specifics of the operation, al-Awlaki, if someone's a citizen of the United States and is a terrorist who wants to attack our people and kill Americans, in my book, that person is a terrorist. Excuse me, Leon. How are we deciding that someone is a terrorist? What information did we have about al-Awlaki? Nasty piece of work? Absolutely. Deserving of bad things? Absolutely. Do we have the evidence that would meet the requirements that John would accept that he was directly participating in hostilities? Do you really have that evidence? And who double checks it? You don't need to go public with the whole lot. And then, of course, there's the whole thing of the legal justification for this. And that's where I do part ways with John. I think this notion that able or unable or unwilling is part of customary law is actually deeply problematic, although you said we probably wouldn't disagree on it. Basically what you're doing is what Panetta is doing here. You're setting up the United States to make its own assessments without any documentation, without any argument. We assess that al-Awlaki is a terrorist equals taking a direct part in hostilities in a context that we declare to be an armed conflict. No one's checking that. No courts, no one. It's just internal. We've looked at it carefully. We're confident about this. Australia is unable or unwilling to take action against someone that we in America think is a terrorist. Well, excuse me, you think that we are unable or unwilling? We presumably don't think that he's a terrorist for some reason, or that such action should be taken. So it's a wholly subjective test if we were to go down the unable and unwilling route. It's not surprising that the US State Department is now pushing that line. It has no support that I'm aware of from any other government. Maybe the British, because they are compliant like the Australians in a lot of these things. But generally it's a test that I would find highly problematic. Leave it at that. I think you guys are now supposed to, if there is any time, where's Alex? Alex, you've done all the work,
yeah, feel free to ask questions and you guys answer.
I had a question about consent which you raised earlier. What do you do about when the state is under some sort of duress, or you're dealing with a non-democratic regime, or the consent itself hasn't been democratically consented to?
Where the state has consented in some secret way that the public doesn't know about, I have problems with consent as a basis for anything other than the entry onto the territory of a state, for starters, right? Because it is purely a question of the resort to force or the violation of the territorial sovereignty of the state in which the suspected combatant or terrorist or what have you is. But again, these, when you have a government or a individual or a group that's the established, recognized government of that territory, or even the de facto government of that territory, I don't know that international law has anything to say about whether that consent is valid or invalid. There may be a democratic participation problem, there may be some other problem, but international law generally will accept the consent of whatever is accepted to be the government of that territory. And other states, I think, are reasonable to rely on the consent of whoever the accepted government of that territory.
But as John said in his first comment, the consent is only, yes, you can come into our territory. The consent is not you can kill any of our citizens. You're still bound by the relevant law as to whether you can actually carry out a target.
So in a place like Yemen, where you have consent, but you have a government that clearly doesn't have control over its own territory, what paradigm or legal paradigm prevails or governs the attack there? Is it, you could look at Al-Qaeda in the Arabian Peninsula and other actors, non-state actors, rising up against its government and say that we're intervening in an internal armed conflict on behalf of the government, but only if you can establish sufficient linkage between the non-state actors battling the government and Al-Qaeda in the Arabian Peninsula, and Are they associated forces or co-belligerents, or however you like to say that? Or are they, is Al-Qaeda in the Arabian Peninsula merely taking advantage of the governance vacuum that's been created by internal conflict? All of these things are heavily factually dependent, and that's why it's completely understandably very concerned. But a lot of what we do in international humanitarian law specifically is very subjective. The proportionality requirement that an attack not be clearly excessive in relation to the direct and concrete military advantage to be gained, that is largely in the eye of the commander. And it's only in the extreme cases when you're going to be able to label an attack as an indiscriminate attack. Otherwise, the commander has some judgment in determining what he believes, he or she believes is the direct and concrete military advantage to be gained, and what's clearly excessive or not. And so a lot of the way the law works, and this goes back to one of my very first presentations, it demands, it requires voluntary compliance. No rule of law, no system of law will survive without voluntary compliance. And so we have to, as Philip said, we have to have those internal accountability mechanisms, whether they're public or not. Better that they're public, but we have to have them.
I have one question concerning the differentiation between combatants on the one hand and civilians which only for a certain time take part take an active part in the hostilities and then draw out again. I remember a judgment from the ICTY in which this, daytime civilians, nighttime combatants, I think it was the Blaschkitsch appeals judgment, said that this is not a workable standard. Somebody is either a combatant or is not. And I imagine that if the names of these people already appear on some lists somehow, then there must be. I mean, you gave an example how such names can come on such lists, but there might be a possibility of a check, as implied. By you to make sure that it is a combatant and not even maybe a civilian at that point.
Philip's report actually kind of addressed this, in terms of the general report on pattern of life activity and the problems, and the fact that the direct participation in hostility standard seems to be unworkable. It's definitely problematic and contested. The International Committee of the Red Cross has tried to provide guidance on it. So it's still a standard that applies. But it's a highly problematic one, in part because states and lawyers, for that matter, can't agree on what direct participation in hostilities is. You can ask, generally not military lawyers, except ones who are not as well-versed in this body of law, but even military lawyers in the U.S. Army, what direct participation in hostilities entails. And some of them will tell you factory workers, and others will tell you no. I asked that same question in my class down at Rutgers, and most of them thought factory workers should be considered as taking direct part in hostilities. So I think the International Committee of the Red Cross guidance was absolutely essential, but it still hasn't fully clarified everything.
What's the factory? Is it making baseballs or?
Well, military-industrial complex, of course. Yes, sir.
I had a question either of you might want to address, which is whether our society, which has some dysfunction, really is choosing, either de facto or de jure, to give up some transparency and accountability in exchange for feeling more secure. Because there's so many other examples that are very prominent in society about where what we appear to choose is not what we really want, such as negative advertising, by which we may end up with President Romney instead of President Gingrich, and even though we're against the negative advertising. Or freedom of speech and advertising of products, and so we're all overweight and unhealthy because we buy what's advertised, even though we all think there's too many commercials and the food isn't healthy. Or, whether Facebook respects our privacy, but we want Facebook so much that we are conflicted about whether it should be more transparent and whether we should have more control over our data. So to say that we even choose to pass laws in theory that regulate accountability in this field of extrajudicial killings may not be realistic. And it may just be a total fiction that we're choosing anything.
Did that stop with a question?
Yeah, well, I think that's that raises a whole range of issues. I'm not sure how to take it in the sense you go back to the answer that some would give to my presentation is, excuse me, sir, but you don't realize that the United States is a democracy. In other words, we have an elected Congress, we have an elected president. They make the choices. It's therefore we voted for them. But it's of course not that simple. My assumption is that it's true that something needs to reach a certain threshold before the public really gets agitated by it. And the United States public, I think, is not actually particularly agitated by tiger killings at this stage. It doesn't affect the US. It hasn't caused any major kickback so far overseas. Hamid Karzai has a fit every now and then, but we can live with that. And so it's not really on the radar screen. It's not an issue of public debate. All of the Republican contenders sort of competed with one another as to how many people they'd kill and from what distance, rather than getting into any of the issues I've raised. So, yeah, if that's your point, I agree with it.
Smartphones are great. It was Federalist number 8. Alexander Hamilton said, to be more safe, they will be willing to become less free. Now, he was talking specifically about the need for a central army and the Union, not separate states which will have their own armies and create a constant situation of conflict. But the basic human instinct, right, is there. So certainly it seems a lot of legislation has passed, and whether you could say it's a result of what's happened with our electoral process and that representatives aren't representing their districts anymore, or their people, they're representing various interests. However you want to go about it, it's certainly been placed in the law, and the courts can't always fix everything, right? And each of these creates their own constitutional issues.
So it sounds like you're both saying that the theory of law of extrajudicial killings holds up a lot better if nobody's really paying attention.
Well, I think that the whole, in my opinion, the whole use of force by the United States has gotten to that point. We have less than 1% of the American public serving in the military. There's a very large democracy deficit, I would say, in the use of our military overseas, and not very much interest in exactly what they do over there. More so now that you have 24-hour news, but still not as much as one might like to see. And you also see problems. I mean, even though the U.S. military is getting back to the accountability point that Philip made earlier, the U.S. military is dedicated to accountability. It truly is. But you have seen some very strange results in trials. Detainee abuse cases that I worked on, we got convictions for serious offenses with not much sentence. Then you have the recent guilty plea in the Sergeant Woodard case, the Marine. Squad leader at Haditha and getting a very mild sentence and not convicted for much either. But these have as much to do with judicial processes as they do with lack of commitment, perhaps, on the part of some to accountability. Because having been involved in trying to enforce the rule of law in a combat zone and trying to prosecute detainee abuse cases, you have just as many problems figuring out the truth as a soldier on the ground trying to figure out who's an insurgent or not. It's hard. And then you have to find out the truth in admissible evidence that's not otherwise, a violation of the rights of the accused. And so judicial processes don't necessarily fix these things, which is, again, why I stress the need for voluntary compliance.
A question for Mr. Dehn, less substantive, but you're clearly not in favor of all policies set out by the DoD or I'm sorry. So how do you square commitment to rule of law and transparency and accountability with being a lawyer working for West Point and the military?
this I wrote briefly about in response to Trevor Morrison's article on stare decisis in the Office of Legal Counsel. He published that in the Columbia Law Review. And in the sidebar, I challenged the notion that, either that the Office of Legal Counsel, the office within the Justice Department that provides legal advice to the CIA and the President, ultimately determines the executive branch's legal opinion on any given matter, that their opinions are law, some sort of law within the executive branch, which is the claim. Since they're the senior, highest legal office in the executive branch, their word is law. Their interpretations are law. And that it's law that should be followed by subordinate legal offices, or followed as precedent, or that you're somehow bound to this. I think as a lawyer, you have to resort to your personal, professional ethics. Right? My job as a lawyer is to provide independent and accurate advice to the best of my ability with thorough research. So as I made clear in the comment, the cases that I prosecuted, I actually was assigned to because there was a lack of accountability for various reasons for 14 months after a couple of detainees died in custody. And then about 3 or 4 weeks, I can't remember, before the Abu Ghraib photos were published, and then the whole enhanced interrogation debate became all the rage. And eventually, the Office of Legal Counsel memos started to leak out, and as I said in the article, I didn't feel like I was bound to a clearly result-oriented legal opinion. I don't care who gave it. My obligation as a lawyer is to the law, to the system, to the legal system, not to some executive branch lawyer who, in the words of Jose Alvarez, tortured the law. So I think you have to look at fundamentally what your role is as a lawyer, and stick to it. Government practice is difficult because, and it's not you're not an advocate. You're never an advocate. So you don't have to adopt your client's worldview unless you're working for DOJ and you have to represent the government in court. But it's a temptation because you want to make your client happy. You want your client to come back and continue to seek your advice. So the institutional pressure is always to, and I say your client, I use the term loosely because who is your client? Is it the person to whom you give advice? In my opinion, no. That's an advisee, but not a client. The agency to which you give advice? In my opinion, no. Although that's the general view within the executive branch. As a lawyer, your client is the agency. For the Army, the rules that they've adopted say the Army is the client. The Army is the organizational client, not the commander that you advise, not the... I took an oath to the Constitution. I think my client's the federal government, created by the Constitution, just like a corporate attorney who advises a corporation that's formed on the basis of a corporate charter. And that situating yourself in that way kind of helps you understand how to look at the law, right? Because if you resort to advocacy mode, as the Office of Legal Counsel says they don't, but appears to, then you tend to develop a legal opinion that favors your client before the policy decision. And that's risky. That's your job when you're an advocate, but it's not your job when you're an advisor. So that's my take on what it's worth.
As far as the Office of Legal Counsel, I know right after al-Awlaki was assassinated, the Washington Post leaked that memo that was their justification for that.
New York Times, but yes.
That was the Times. And so I was wondering how that plays into what you were saying, the judicial process of review for these targeted killings, and also what the process is in the intelligence committees in Congress of what information they are getting. Are they signing off on any of these killings? What information are they getting? And is the CIA just saying the not confirm, not deny line to that?
Generally what the covert action statute requires, and then we could have a debate about whether it is effective, because there are some who would argue that the presidency has inherent power to do what the CIA does, and it doesn't need Congress, and certainly Congress can't restrict the president in what he does in foreign affairs. But putting that aside, covert action requires that the president make a finding, which is classified, and that national security requires a particular action within a foreign country to affect conditions in a foreign country. And that's reported to the intelligence committees. It's not, now, it's a programmatic decision finding, right? So it's not necessarily going to be, you know, it's going to be a general program, not a specific operation, I guess is what I'm saying. Right. So Congress doesn't necessarily have any oversight over what's done or how targets are selected if it involves that within that program. But as we've talked about before, you know, there's, I've talked about elsewhere, I think there is a definite constitutional requirement for some form of judicial review when it involves depriving a U.S. citizen of his rights. But the courts have not agreed. Not only did the Al-Awlaki court decide that attacking a U.S. citizen who was part of a foreign organization as a threat to the United States was a political question, but I think the cases of Rahr v. Ashcroft, they also held that a Bivens suit was precluded by a political question presented in that case. And so where we're going to come out on this, I don't know. But it would be preferable, of course, to have some sort of after-the-fact judicial review, even if it's in camera. Well, I mean, you know, we have the FISA court. They've done things like this. Why couldn't, if it has to be an entirely closed proceeding, it's at least an.
So right now, there is no proceeding. Okay.
Well, under the case law, it's going to be near impossible to get any case involving a covert action into the courts. The state secrets evidentiary privilege prevents it. And the courts not even getting there. They're saying political question. I'm sorry, Rahr involved state secrets and Al-Awlaki political question. Yes, sir.
Even before you get into the courts, I mean, both of you have raised a lot of concerns about disclosure and so forth, but would you agree that there's certain things that should never be out in the public, that there's certain military operations that, I mean, as part of military operations and part of the CIA, that things are just always going to be secret? Where do you draw the line?
I think there needs to be a public framework. We need to know what sort of guidelines are applicable in terms of determining what is going to be done in our name, whether by the CIA or DOD. There needs to be some sort of review of actions that have been taken. I'm not suggesting the intermediate point that you're focusing on, that every single action needs to be made public. Obviously, can't go that far. But at present, we have no review at all at any point, and we don't have the framework. So, you know, in relation to the earlier question, the New York Times leaked a report about the OLC memo, but not the memo. We still haven't got the memo. That should be a big issue in the coming months. We should get the text of the memo, but so far not even that. Just take it from us. We have the authority to kill Americans, and we have good legal arguments. We're not going to tell you. No, that's very different from giving the specific operational details of a particular exercise. It's knowing what is the legal authority that's claimed, on what basis, and to what extent do we make sure that operations remain then within the agreed legal framework.
And back to your question about whether certain things have to remain classified. Sometimes they do. But generally, so for instance, if the government's going to prosecute someone, they have to reveal the evidence that supports the prosecution, right? And at least under the military justice system, and to some extent in the military commissions, if you don't reveal relevant classified information to the defense, the court can abate proceedings or, you know, dismiss certain charges up to which that information. But generally, the failure to disclose, I mean, you could winnow from that a general principle that when you're going to affect a substantial right of a U.S. citizen, then you have to disclose material to the court, right? I mean, if you can evade a prosecution which would result in their detention for whatever the statute allows. Why can you kill without ever disclosing a citizen, without ever disclosing your evidence or legal basis?
I think I don't want to take too long, but I want to make, maybe this is a gratuitous comment about US policy across the board, but the whole issue of transparency strikes me as unbelievably confused in the current setting. So just to give you a couple of examples, what's his name, Kyriakis or whatever, the CIA agent who revealed a couple of details, has just been prosecuted by the administration. The administration is very keen. They've pushed a number of really tough prosecutions against people who have leaked information. And that's all premised on the fact that all of this must remain secret. We cannot divulge any information. The other side, you've got this book by, is it Joby Warwick, is that his name? I should know, I read it. It's about the attack on the CIA based in Khost in Afghanistan. And Hobie, whatever his name is, Joby Warwick, gives every last detail of the CIA agents who were involved in it, every last detail of their personal lives, every detail about, back at headquarters, these were the instructions that were given. It's leaks galore in all directions. But it's a very favourable book for the CIA. It's a patriotic book. Not a word has been mentioned about there being any problems. And the number of leaks that go through journalists. When I was UN Special Rapporteur, the US government would give me no information, whether it was State Department, whether it was CIA. I met with the Inspector General of the CIA. We talked for a long time, and I said at a certain point, "Would you be getting back to me?" And he looked at me and said, "What? Me? Get back to you?" No. I'm sorry, I'm just here to collect information, get your views. Thank you very much. But then I had journalists who'd say, "Hey man, I've just come back from Langley, and they told me this, that, and the other thing." And I'd say, "Well, lucky you, I've never got to Langley, I've never talked knowingly to a CIA official." But, when they want to leak like a sieve, they do it. And then suddenly there's the harsh crackdown and the insistence that all of this must remain secret. It's a really Orwellian world, I think, that we've got ourselves into in terms of both the policy and the practice.
I think we have to stop. But thank you all for coming, and thank you for... Yeah, feel free to take it.
My buddy just got back from Afghanistan. Or he's a Marine, but his job was, he was in charge of keeping confidential information and proceedings. Like, when he came back, I talked to him. I was like, so what's going on over there? He's like, I can't tell you really anything, but he's like, it's more than you would imagine.
Well, I want to know.
The things he probably knows. I mean, he's in 2 years in Afghanistan.